Hello, this message is brought to you by the Contra Costa County Bar Association's Lawyer Referral and Information Service. I am a lawyer in the San Francisco Bay Area, practicing in the area of trusts and estates. I'm here to help you if you are preparing an estate plan or administering a trust or estate after the loss of a loved one. Estate planning is a process. It involves people, your family, other individuals, and sometimes charities. It also involves your assets, specifically ownership titles and beneficiary designations. Many people think that estate planning is simply the writing of a will, but it encompasses much more. Estate planning may involve financial, tax, medical, and business planning. A will is one part of that planning process, but other documents are needed to fully address your estate planning needs. If you don't make a will, the state has one for you. California law provides for the court appointment of an administrator to manage and distribute your estate. This may or may not be the person you would choose. It could be a stranger. State law also determines your heirs. If you are married or have a registered domestic partner, your spouse or partner receives all of your community property. Your spouse or partner will receive part of your separate property, and the rest of your separate property will be distributed to your children or grandchildren, parents, siblings, nephews and nieces, or other close relatives. If you are not married, your assets will be distributed to your relatives in the same order I just described. Friends and charities will receive nothing. If you want to decide who will inherit from you, or if you want to disinherit anyone, you should make a will. Whatever the size of your estate, at a minimum you should have an estate plan that includes 3 documents: a will, a durable power of attorney for finances, and an advance health care directive. A will is generally defined as a document intended to dispose of an individual's property after death. It is also commonly used to nominate an executor for the estate and a guardian for minor children. A durable power of attorney for finances appoints a person called an agent or attorney-in-fact to manage your property and make financial decisions for you should you become incapacitated. The agent must manage your assets in a prudent manner, accountable to you, and solely in your best interests. An advance health care directive states your health care wishes. You can nominate an agent to carry out your health care instructions and make decisions for you if you become incapacitated. In addition to providing instructions about organ donation, disposition of remains, and services, the advance health care directive may also state your wishes concerning life-sustaining treatment. This is sometimes referred to as the living will or pull the plug. You should also make a list of your assets and debts and keep it in a place known to your executor or other family members. This will be of great help to them if you are not able to share that information. Depending on your situation, you may also want to avoid probate. Probate is a court-supervised process that may be required to transfer assets to beneficiaries. It is not automatic, but must be initiated by a petition. Typically, the executor files the petition. If there is no will, the court will appoint an administrator. Probate is required when the probate estate exceeds $150,000. The probate estate includes assets titled in the decedent's name alone. The probate estate excludes assets held in a revocable living trust, a spouse or registered domestic partner's half of community property, assets that transfer automatically to a surviving co-owner when property is held as joint tenants or community property with right of survivorship, assets that have beneficiary designations, including some life insurance policies, retirement accounts and annuities, and bank accounts, other securities, and vehicles with transfer on death or pay on death designations. In this regard, it is worth noting that neither a trust nor a will trumps community property rights, rights of survivorship, or beneficiary designations. Those assets pass by operation of law, not pursuant to your trust or will. If your probate estate is less than $150,000, your beneficiaries may follow a statutory procedure to transfer your assets, subject to your debts and expenses, without probate. However, if you own real estate, you should be aware that the probate threshold is much lower, only $50,000. Probate has advantages and disadvantages. A court proceeding may be desirable to settle creditor claims or approve actions and accountings that might otherwise be disputed by the beneficiaries. In most cases, though, people try to avoid probate because of its expense, delay, and public nature. A revocable living trust is a written agreement involving three parties. First, the person who creates the trust, who we call the settlor, trustor, or grantor. Second, the person or institution who will manage the trust property, who we call the trustee. And third, the beneficiaries. If you make a trust, you may be all three parties, settlor, trustee, and beneficiary, so long as you are living and can manage your property. Because the trust is revocable, you may change it whenever you like. Significantly, though, if you lose the ability to manage your property, the next trustee will continue to manage the trust for your benefit. And eventually, when you pass away, the trustee will distribute your assets to your beneficiaries as you instructed in the trust document. In this sense, the trust acts as a substitute for your will and eliminates the need for probate with respect to assets that were in the trust. Even if you have a revocable living trust, you should still execute a will. We call this a pour-over will. It provides for the transfer of any assets held outside the trust, in your name alone, to the trust following your death. In addition, if you have minor children, you nominate their guardian in your will. A living trust can be an important part, in many cases the most important part, of your estate plan. It is possible to do your own estate planning. Online services and other do-it-yourself estate plans are just that. They do not provide any legal advice. If you want to be confident that your wishes will be carried out, you should speak with a qualified lawyer. If you are administering a trust or estate for another loved one, you are not required to hire a lawyer. However, unless you have experience and understand your obligations, including your fiduciary duty to the beneficiaries, it is prudent to seek professional advice. In your area, there should be a Lawyer Referral and Information Service sponsored by your local bar association. You can usually find the service in the Yellow Pages or on the Internet. The Contra Costa County Bar Association's Lawyer Referral and Information Service in the San Francisco Bay Area can help you find answers to legal problems by giving you an initial consultation with a lawyer near you at a very low cost. The lawyer can explain the specifics of the law in your case and can answer all of your questions in detail. I hope this helps you to better understand when you should contact a trust and estates lawyer, and that I've answered some of your questions about estate planning, trust administration, and probate. Thank you.